B. Moninger. Am I pronouncing that correctly?
Yes.
I know state I'm doing correctly, but Moninger. At least I hope I'm doing state. Our case number 1CA-CR190353. This is the time set for oral argument. Counsel, thank you for appearing telephonically. I actually had one of my children tested positive, so I was going to have to move this to lockdown anyway. So your motion was was perfectly timed for us. And I'll save you the question. She's fine. We're all fine. But we have each side has 20 minutes. Appellant, you're allowed, of course, to reserve some time for rebuttal. And there will be a clock on the screen, which just showed up on my screen. But you'll have to police that yourself. We don't do it for you. So when you get to where you've got some time you want to reserve, you need to wrap it up and do it that way. We have conferenced this case, I think, twice now, but we just conferenced it again this morning and discussed the case. We're very familiar with the briefs and the record, so keep that in mind when you're making oral arguments. This argument, I believe, will be recorded and later posted to YouTube, so you can watch yourself and us and evaluate your performance later. I don't think there's anything else I need to discuss. Judges McMurdy and Cruz, have I left anything out?
No.
All right. Well, we'll then proceed and counsel for appellant.
Thank you, Your Honor. May it please the court. My name is Jill Evans and I represent Mr. Moninger. We are asking this court to vacate counts 2 and 3 based on multiplicity, since all 3 counts of luring a minor for sexual exploitation are based on one act of solicitation for sex of a minor under 15 within one continuing conversation.
Counsel, is that the, you say it's one act of solicitation. He solicited her multiple times, right? I mean, he over and over again asked her to meet him for sex.
Well, I think you have to focus on what the unit of prosecution is, and our position is that the unit of prosecution is one solicitation for sex on Friday, and that it was continuing conversation.
I'm sorry, just a moment. There's a problem with the audio. I'm starting to lose it.
I couldn't hear you either, Miss Evans. So.
Uh-oh.
Okay, you're fine now.
Okay, I'm moving closer. Maybe that would help.
That's
I think
perfect.
it looked to me actually
Better?
like when you looked down, like I think you were reading something.
Okay.
When you put your face away from the mic, we couldn't hear you.
All right, let's try that again. So the argument is that one solicitation occurred for sex on Friday, as is clear in the conversation, which continues from the point of October 3rd through October 5th, that it's one continuing request for a sexual event that's going to occur on Friday, and all of the conversation pertains to that one solicitation. There's not 2 different solicitations, for example, for a sexual event at a hotel versus a sexual event somewhere else, like at the lake. There's not a break in the conversation between one solicitation and then a break and then a second solicitation, but it's an ongoing request.
Well, there was a break. They would end the conversations at night and then repick them up the next day. So there was a break in the conversations. It's just you think that's all one conversation with some rest periods during it.
Yes, I mean it's a text, so you can continue a text over a period of time. I mean, I think there's
Miss Evans, I don't know what's wrong, but I can't hear you again.
Yeah.
Can you hear me now?
Yes.
Yeah.
So even if there's a break, it's an artificial break in the sense that a text you can respond at any time. It's the same conversation. Even if there were a human sort of voice conversation, I'm sure you've always, as a parent, at times said something like, well, this conversation, we're going to continue this tomorrow. It's the same conversation about the same subject. And in this case, when you look at the text, if you actually look through them, they always are talking about Friday. On Wednesday, they're all talking about Friday. On Thursday, they're talking about tomorrow. The texts are numerous and surround all of the separation of the dates that the state has separated out. Texts.
Ms. Evans, I have a few questions I'd like to ask you. It deals with the particular argument that you're raising. Did you ever raise that particular argument with the Superior Court?
Whether there was no, I don't believe it was raised, but it's a multiplicity is a double jeopardy argument, so it can be raised on appeal, and it is reviewed regardless. It's considered fundamental error.
Okay, so the answer is no, you didn't raise it. And then the second question that is, did you ask for a jury instruction? A jury instruction that would have focused the jurors on this particular issue, the unit of prosecution?
I don't think there's a specific jury instruction, but there is a jury instruction to consider each count separately, and they were charged as 3 different counts. So, but that probably is a different issue, yes.
Well, right. I mean, the way I understand your theory is the unit of prosecution was the entire encounter from the first day to the second day to the third day. So that didn't tell the jurors what different evidence they need to look at on for those specific counts, did it?
No, but the state argued 3 separate counts of in closing. The defense was entrapment, so the defense focused on one overall event, and as a matter of fact, admitted in testimony and argument to one event, basically, and that was consistent with the attempt at the same conduct.
As I understand the law regarding entrapment, and I don't want to make an argument for the state here, so I don't know that they argued this in their briefs, but when you argue entrapment, you have conceded that the state has sufficient evidence to prove each of the underlying counts.
The entrapment defense was that he committed a solicitation and an attempt at sexual conduct on Friday. And if you look at the testimony, the argument, it's all that general admission to Friday.
Did you ever do anything on the record to say, look, we're only conceding it as to count 1 or count 2 or count 3?
No, I don't think there was anything like that. I mean, it was general admission. It was a general admission both in the testimony and in the closing argument as to the fact that there was a solicitation and an attempt for sexual conduct on Friday. And then he shows up, and that's what everybody focused on. So
would you agree that if there were, and I'm not saying for your case, but just in general, that you have a case where the parties agree to meet on Friday, and there's discussion of maybe different sex acts or well, let's say that different sex acts during the course of what they're going to meet on Friday. Could that be sufficient to give rise to separate counts, even though it's all going to be one meeting?
Well, here the charge was for sexual intercourse, so they were limited to that that greater sort of conduct, and that's
right. But each act of sexual intercourse could give rise to a different count of sexual conduct with a child. So even though it was sexual intercourse, if he said, for example, and I hate to use graphic terms, but I want to have sex in traditional missionary position with you, and then on the second day he says, and I also think it'd be fun if we used another position. Couldn't that give rise to separate counts of solicitation?
I mean, I think if they're distinct, separate acts, yes. Just like as in sexual conduct rape cases or sexual conduct cases with different types.
Ms. Evans, I can't hear you.
Such as rape cases and cases of different types of sexual conduct, they have been permitted to be distinct as long as there's a clear break, a beginning and an end, and a clear distinct difference. Obviously not a continuing sexual act, and that's what we're arguing here. It's more like a continuing request for the same
I'm sorry, you're starting to fade again. I don't think it's your proximity to your computer. I think there's something about the internal mic on the computer. Maybe if you have an external mic, like, headphones, that might help. But it's not your proximity because it can happen when you're close.
Yeah.
Are you hardwired in your laptop?
I am actually, and we did an argument before, and I didn't have a problem. So I apologize. I don't know what is
It
happening.
starts to sound very synthesized. Would that be the word?
Yeah.
Kind of. Yeah.
I'm blaming Mr. Ball for this. I think he's a part of this conspiracy to mute his opponent.
All right. Well, Miss Evans, I'm hearing you well right now, so we'll stop you when you give us problems. And our timekeeper's been doing a great job of stopping when we've been interrupted because we can't hear you. So I think we're not stealing too much of your time.
Okay. Well, I apologize again. Yeah. So
well, let me ask the follow-up to that question then. So, and again, not talking about your case, but the hypothetical case, even though it was all one continuous conversation, if there was enough evidence there of distinct sex acts being asked for, even if it was intercourse each time, but just different forms of intercourse, you could have multiple convictions.
yes, I think that's true. It's sort of like, distinct requests for, two different types, two different murders. This would be two distinct types of sex, and so I think that there could be, but in this case, it was charged as sexual intercourse, and I think there's only one continuing request in this case for sexual intercourse on Friday that occurred.
But there are, Ms. Evans, and not to put words in your mouth, but there are state cases that talk about solicitation to commit murder. If you're soliciting one person to commit multiple murders, it's still only one act of solicitation. So if you're soliciting one person to have sex with, what difference does the solicitation mean if you're saying different acts?
Well, first of all, I don't think that this case raises the multiple victim issue that you're talking about there. And even if you could have one solicitation with multiple victims, I mean, the solicitation, you still look at what is the crime that's being solicited. So you still have to look at the communication to discern what that is. There could be two different solicitations in one conversation. It's just that in this case, there was not. So you have to look at the context of the communication.
Wouldn't it have been better if there'd been an instruction that had pointed this all out to the jury that they needed to do, rather than just, day 1, day 2, day 3? And why didn't you ask for? You weren't the trial lawyer, but why wasn't it asked for?
Well, I don't know why it wasn't asked for. I'm not sure what instruction. Are you referring to unanimity instruction or?
No, I'm talking about a unit of prosecution instruction that specifically lays out exactly what we've been talking about.
I think there was an instruction that each, like I said, that there had to be, sufficient evidence. The state had the burden of proof to prove each beyond a reasonable doubt. So that sort of covers, I think. But yeah, there wasn't one requested below. You're right. So
what exactly is our standard of review? Because it sounds like you're saying you could have a conversation, even though it's one continuous conversation, that resulted in properly charging multiple crimes. And we have a jury that found these conversations resulted in multiple offenses. So shouldn't we be applying kind of a sufficiency of evidence review? Is there any reasonable jury that could find these conversations resulted in multiple offenses?
Well, they actually did find that they supported multiple, which is a violation of double jeopardy if they don't under the law. So it's you have to look at it as whether, I think the unit of prosecution is an interpretation of statute, and so whether or not there can be or not would be legal conclusion, and then that would be reviewed as fundamental error.
Well, hold on. If we're going to create a unit of prosecution for the luring crime in this case, in a future case, isn't the jurors going to have to be instructed on what that unit of prosecution is to resolve the factual disputes that may come up?
You could come up with a.
Oh, I don't have to come up with anything. I'm saying, isn't that what they're supposed to be shouldn't there be an instruction? We don't wait for after the fact for the Court of Appeals to look down their snotty noses at the case and try to figure out what the jurors did. Do we?
Well, I mean, I think that the instruction could be that there has to be a solicitation. They're the elements of the offense. There has to be a solicitation, and the jury decides whether there's one or more within the conversation. So it's covered by I think the elements, but on review, you have to determine whether or not the elements were there.
Well, except Ms. Evans, I hear you advocating for a particular limitation on a unit of prosecution for luring, and yet I don't see anything in the jury instructions that would impose that limitation on what the jurors were supposed to be considering.
But regardless of whether there's an instruction or not, you still have to look at whether or not, for double jeopardy purposes, there was or was not multiple units, or a consideration of multiple events when there was just one unit of prosecution as a standard of law. So yes, I mean, in this case, I think that the jury would still have to determine, I mean, whether or not there were one or more offers for separate sex on one or more days. So it would still be a jury determination, but yeah, I mean, so go ahead.
I have a question. Under Arizona law, solicitation is complete when a person commands, encourages, requires, or solicits another person to commit a felony. So why shouldn't we find that the additional communications after Sabrina agrees to engage in sex, to have sex with Mr. Boninger, why can't we say that the subsequent conversations were part of the encouraging that happens under solicitation?
They are all part of the same encouraging, offer, solicit for the same sex on Friday. That is part of the continuing, several parts to the same request.
Right, but my question is, why isn't, if solicitation is complete when a person is encouraged to commit a felony, why isn't every encouragement a new crime?
Because as in rape cases, for example, each event, there has to be a clear break and a beginning and an end to each event. And it would be sort of absurd to take 400 texts and bring out each one as a separate when they really are part of the same event. And it's sort of like in sex cases, you don't separate out. Is there
Oh, you're
Hold on a second.
Hold on.
Miss Evans,
We lost.
hold on.
And did we lose Mr. Ball, or did he just decide
he's
he had
there.
enough?
I can't.
He's
see
just
it.
holding very
I
still.
Okay.
Oh, I've just got
All right.
CB. There he is.
All right.
All right.
Back up
Can you hear
a
me
little
again?
bit.
Okay.
Yes.
Okay. So as in sex cases, they may have to make sure there's a sort of a clear beginning and an end. So it's not divided up into sort of multiple things that happen during one continuous sex act. And that's sort of similar to here. There's a beginning and an end to the encouraging that leads, if you look at the language of all the text, is all part of the same encouraging leading up to the event, which is the sex conduct on Friday. So similar to sort of Bruni, or, distinguished from the rape cases. Yeah.
But your client wasn't sure they had an agreement, was he?
Well, he attempted to complete it by showing up on Friday.
No, I mean on each day. On the third, even though they've got an agreement, he says a couple of times, like, are you sure you want to do this, or you don't really love me? And he, oh, I thought you were. I can't remember the exact words, but I thought you were. When she didn't respond quickly, he wasn't. He was worried that she had changed her mind. And then on the fourth, text number 953, he asked her, "You don't want to meet me?" Why should we care whether the victim, or in this case the detective, had expressed an agreement? Isn't it a question of his state of mind as to whether there's an agreement, whether he's continuing to solicit to make sure that agreement is carried out?
Well, yes, but I think that it's just a continuing conversation requesting the same thing. So I don't think the references that you made are a distinct beginning and an end.
Well, let me ask you this then. If she had said no when he asked, we'd have a completed crime, wouldn't we?
Yes, I agree with that. Actually, if you reinitiated after that, there could be a good argument for that.
So she says yes, but he's not sure she means it. So he keeps asking her over and over again to reconfirm. Why is that not a completed crime each time he gets a reconfirmation?
I think it's, again, the same argument, really, just that it's a continuation of his same request for one event, and that's Friday. I see that I have very little time left. I'd like to reserve that for rebuttal. Thank you.
With the other judge's permission, I'm going to add another minute on just because I figure we lost a little time with the mic problems. Sure. Judges McMurdy and Cruz, do you have any objection to that?
No, that's fine.
All right, so we'll give you 2 minutes and 41 seconds for rebuttal. And if Mr. Ball has problems, we will afford him the same as well.
All right, good morning, Your Honors. Can everyone hear me?
Yes.
We can.
May it please the court, my name is Casey Ball, Assistant Attorney General here on behalf of the state of Arizona. This court should affirm Moninger's convictions and sentences because the convictions are not multiplicitous and the DCAC sentencing statute requires consecutive terms of imprisonment. Most of the conversation so far has been on the unit of prosecution. I want to start by making a important distinguishment between inchoate offenses like solicitation and the offense of luring a minor. Our Supreme Court in Majak v. Granville explicitly held that luring a minor is a completed offense once the solicitation occurs. It's not an inchoate offense.
Hold on. So under that theory, and I know that's your position because you put it in your brief, under your theory, then every time he sent a text, that was a completed act.
Every time he solicited sexual conduct from a minor, not every text had a sexual component to it, but every time he sent a message.
So every time he sent I want to have sex with you, or asking a question, then on day one, for count one, there were multiple crimes committed under your theory.
Correct, Your Honor.
And so isn't that also a problem? Isn't that a duplicitous problem?
There are concerns of duplicitous charges when the state presents multiple acts that could constitute the crime. However, this court in State v. Klokik held that when the defense is the same for all of them and the acts occurred in a continuous event, then the judge doesn't need to instruct the jury that they need to be unanimous as to one specific act, or the prosecutor doesn't need to identify a specific text that constitutes the act. So
and doesn't duplicity also need to be raised by the defense before trial?
So for the duplicitous charge, it's a little different than a duplicitous indictment. The defendant can't raise it until trial because it's based on what the state presents. However, it is reviewed for fundamental error if the state does not raise the objection at trial once the evidence has been presented. But
If
in
the
Cloak,
defendant doesn't raise it.
yeah, if the defendant,
said
I
the
said the
state.
state, my bad, if the defendant doesn't raise it, yes. So we don't really
Well,
have a duplicitous.
Let me ask you a question. And this is a hypothetical. I know it's not our case. That's why I'm asking. So the defendant contacts an undercover police officer and says, I want to purchase drugs from you. And the other undercover police officer says, sure, I got whatever you want. And he goes, the defendant says, I want to purchase a pound of cocaine. And I'll buy it from you for whatever amount of money. I don't know what it's going for nowadays, but I'll buy it from you on a particular occasion, a date certain. And this is a nervous Nelly kind of defendant. So he keeps contacting the police officer, and he contacts the officer, I don't know, 5, 6, 7 times to reaffirm the sale of the drug on a particular day at a particular time. Has he committed an act of soliciting the sale of a narcotic drug on each time he sends the message or each time he makes the phone call?
I mean, he's soliciting it each time he asks, but the difference is that that would be an inchoate offense under the Chapter 10 solicitation definition. I'm not sure. I know for purposes of the conspiracy inchoate offense, you can only have one conspiracy no matter how many times you have a conversation about it. Here, we've got very
the solicitation is different. As you pointed out, we look at the solicitation. We look at, is it completed upon the act, the communication?
So for the purposes of luring a minor, Majak v. Granville says it's complete as soon as the offer is made. And the same is held in State v. Yegan, where this court was looking at it in terms of determining whether the state had jurisdiction to prosecute the defendant. And this court recognized that technically the offense was completed in California when the defendant sent the messages. But because there was a harm occurring in Arizona, they had jurisdiction to prosecute. So the offense is complete for purposes of 3554 as soon as the defendant sends the message. Judge Morris asked a hypothetical about what if the victim said no, do we have a completed offense? The victim doesn't have to respond at all. As soon as the message is sent, the offense is complete. There doesn't have to be any agreement. There's nothing in the statute that suggests that the victim has to agree or reject it before the offense is complete. It's as soon as...
And there has to be no separate offense?
Sorry, I'm not quite sure I understand, Your Honor.
And well, so you say that the offense is complete, the soliciting offense is complete as soon as the offer is made. There's no need for acceptance on the part of the victim. So every time the same question is asked, regardless of whether the victim is saying yes, I told you yes already, every time is a separate offense.
Yes, Your Honor. And that kind of goes to
even though it's for
policy.
the same act on the
Yes,
same
Your
day.
Honor. Yes, Your Honor. And that goes in part to the public policy. The reason the luring statute was enacted in 2000 was to combat a rise in internet solicitations for minors. And part of the process is to groom a victim. A victim might agree on day one and then get cold feet. And so part of the grooming process is to continue to make those entreaties, continue to solicit the act and reaffirm. In this case, he's offering clothing to her, proposes marriage at one point. It's clear he's grooming the victim for the eventual meeting on Friday. And
so then your position is that the nature of the offense makes it different from a situation as presented by Judge McMurdy, where we're talking about the sale and purchase of drugs.
Correct, Your Honor. In part because with inchoate offenses, there's always another statute tied to the offense. In that case, it would be the.
But there is in this case too, Mr. Ball.
Yes,
and it specifically in that regard, it's identical to the inchoate statute in that you have to offer or solicit a particular offense.
The difference, Your Honor, is that there is a recognized harm from receiving the solicitation in the first place. There's not necessarily a harm.
Okay, where is that recognized?
In State v. Yegan, Yeah.
No. I'm talking about the statute. How do you set you're attempting for us to draw these distinctions between the statute, but the statutes themselves don't draw any distinction, do they?
So I would look to the aggravated luring a minor for a good analogous statute. The difference between luring a minor and aggravated luring is that the defendant includes a sexually explicit image with the offer or solicitation. So I'm looking at 13-3560.
But totally agree with you, but that requires that we look at each time it's sent, and that specifically is by statute. But in this case, there isn't a specificity requirement that says, hey, each time you ask, it's a different solicitation or a different luring.
The language in the statute only says that a person commits the offense by offering or soliciting sexual conduct with another person, knowing or having reason to know that they're a minor. It doesn't specifically have line or language saying this is an act or like a message by message. However, referring back to Yegan, this court cited the legislative history of the sexual exploitation of minor or children statutes, and noted that the purpose of these statutes, at this time luring wasn't one of the crimes, but the statutes as a whole for sexual exploitation of children, the purpose was, and I'm quoting, to prohibit any conduct which causes or threatens psychological, emotional, or physical harm to children as a result of such sexual exploitation. The mere act of soliciting a minor for sex is a harm in and of itself. This court recognized that in Yegan when it determined that it had jurisdiction to prosecute an out-of-state defendant. The harm, the result, occurred here in Arizona.
But Yegan doesn't answer our question, because Yegan doesn't talk about reaffirming or what are there different acts when you reaffirm what was already agreed upon.
Correct. The exact question is not answered by Yegan. This is a bit of a new territory. At some point, the prosecutor is going to have some discretion in charging these acts. In Judge McMurdy, your recent case, State v. Souza, you mentioned that when you decided that this is an act-based unit of prosecution for possession of drug paraphernalia, in footnote 3, you noted that nothing in the decision prevented the state from bringing multiple counts of possession of drug paraphernalia if the defendant committed sufficiently distinct acts of possession based on time or location. So this court doesn't necessarily need to create a unit of prosecution so narrow as a single text message. The prosecutor is going to have a lot of discretion in determining how to charge these acts. The jury is going to be instructed. They were given the elements of the offense. In Yegan, the jury was instructed also on the definition of.
Okay, but in this case, the jurors weren't asked to decide this issue.
No.
Were they?
They were given the elements of the offense, and they were told that there was a charge for October 3rd, October 4th, and October 5th. The prosecutor did a good job of identifying which text messages were the basis for each of those counts. He did it in his opening statement, while he was examining the detective, while he was examining the defendant, and again in closing, so that the jury knew which texts were the basis of each count.
Mr. Ball, let's assume for a second that we are convinced by the defense argument that there's a unit of prosecution related to the goal of the transaction as opposed to the solicitations themselves. Is the evidence here sufficient to affirm the jury verdict anyways? And I'm thinking of questions of like texts like the one I cited earlier, 953 and text 1022, which both occurred on October 4th, where the defendant expressed doubt that they had a completed agreement.
Correct, Your Honor.
So for example, in 1022, he says, I think I can come see you. And in 953, let me scroll up, he says, you don't want to meet me. In other words, expressing some doubt that they had an agreement at that point. Why wouldn't those texts show that at least on October 4th, there was still a new transaction or a doubt in the defendant's mind they had an agreement?
I'd agree that the text showed that there was definitely some doubt of whether he was ever going to show up in Kingman. He was having car problems. I think even the morning of, he noted he was still worried about even making it to Kingman. if this court were to determine that it was a conversation-based and an agreement-based unit of prosecution, there's definitely evidence in the record suggesting that there are new solicitations coming each day. There's also a lot of gaps. In the
hold on. You blew by that. What evidence? It seems to me that in going through these text messages that we're talking about an attempt to have sex with this young girl. And
correct.
Everything was geared to having one encounter or one meeting with this young girl. And we're not talking, there was no evidence about different sex acts, was there?
There was actually conversation about more than just the Friday encounter. At one point, he suggests that he could get her pregnant. She could have her baby.
Well, that could have happened on Friday, couldn't it?
No, he had a vasectomy. He was telling her that at some point in the future, he could have it reversed and get her pregnant if she wanted. He talked about her being the mother of her child. They were talking about having a long-term relationship. So there was more discussion.
Didn't he also mention the being mother of his child, his daughter that he already had?
Correct.
But even the portion about getting her pregnant in the future, I mean, he's still talking about getting together at this time. I mean, that's part of the discussion about why they're supposedly in love and why they should get together, on still talking about October 5th, the same event.
The main part of the conversation was definitely geared towards meeting on Friday, and he was getting his car repaired, hopefully to get there on Friday. But there were other discussions, other long-term plans for a relationship. I'm not sure, though, that is really the key focus of the statute. It really, the harm comes each time a solicitation is offered. There really doesn't need to be an agreement. The language of the statute says offer or solicit. There's nothing about how the victim responds to that or what the defendant intends from it. In going back to Yegan again, the defendant had argued that this was all a fantasy and that he didn't intend for it to happen, and the court rejected that argument and found that the jury could find that there was sufficient evidence of solicitation itself. It didn't really have to do with what the defendant, his fantasy. The defense didn't really apply.
Mr. Ball, if we agree with let's talk about the pregnancy argument for a second. Even if we agreed that that was a different solicit, there's no way we would know whether the jury relied on that to make a determination because they were never instructed on that point, correct?
The jury was not instructed as to a particular text that was the basis of each count. The prosecutor did identify texts.
They weren't instructed that you have to find a different or distinct new solicit.
No, I just pulled up the instructions a couple of minutes ago. So the elements that they were given were just the elements of the crime of luring a minor: offered or solicited sexual conduct with another person, and knew or had reason to know that the other person was a minor. As Ms. Evans noted, they were told that each count was a separate offense and they had to consider them separately. So based on those instructions, when they approached count one, they said, okay, this is October 3rd. Did he offer or solicit sexual conduct on October 3rd? Then, having decided that, they moved and considered separately October 4th. What were the texts that were the basis for that? So based on the verdict forms, the instructions.
But hold on, that's the point I'm trying to ask you. Maybe let's be clear. If you're saying, well, for count two, there was a reference about a pregnancy, and that was a different offer, how would the jurors know that they had to find that to be a different offer than what they relied on in count one if they weren't given some type of unit of prosecution instruction?
So I think this kind of goes back to how this court determines a unit of prosecution. The court starts with the plain meaning of words. I'm not sure that the jury needed a definition of what offer or solicit was, or that it needed a particular definition on the unit of prosecution. For purposes of multiplicity, I think this is kind of turning into a duplicity argument more than a multiplicity, where we're worried that the jury's picking different acts and determining that that is the offense. For multiplicity purposes, it's just whether or not repeated acts of the same offense violate double jeopardy. And where there are separate offenses, distinct offenses, multiplicity isn't impacted. But if it's a duplicitous charge that's the question, Klocek answers that question really clearly. He argued entrapment, he admitted to all the elements of the offenses, and this was all part of a continuous course of conduct. So there's no fundamental error in not requiring the jury to pick a particular text message that served as the basis for each count. I want to just briefly touch on the DCAC sentencing statute. I noted in the answering brief that there has been some discrepancy in the way that trial courts are handling this, just based on a quick review of recent cases on luring offenses. We'd ask that this court issue a published opinion determining that subsection H is the controlling subsection for dealing with probation, and subsection M is the controlling subsection when dealing with consecutive sentences. The way that the statutes are phrased, it's clear that subsection E, which deals with luring a minor, is subsumed by subsection H. Subsection E says that it's not, except as otherwise provided in this section. It gives the impression that you might have a probation eligibility for luring a minor. It doesn't distinguish between first and second degree offenses. When you move to subsection H, H says any offense in the first degree is not eligible for probation. This was a first degree offense. It was a completed offense. The trial court found it was a first degree offense. And so subsection H is controlling here, and probation is just not eligible. Subsection M, there's no tension between that and subsection E. Subsection E doesn't have anything to do with consecutive or concurrent sentences. And so again, subsection M discusses, DCAC offenses are in the first or second degree, either one, must be consecutive, except for a couple that were exempted out. One of which, and luring a minor was not one of those. So
Mr.
based
Ball,
on
your position is different than what the Arizona Supreme Court puts out in their sentencing chart, though, isn't it?
Correct. The sentencing chart is a summary of a lot of different sentencing statutes. Nothing in there reflects that it is completely accurate or that it contemplates every scenario. Much like the old qualified Rajis, it's still incumbent on the trial court to ensure that they're following the statutes. Where you have a first degree offense of luring a minor, subsection H mandates that they're not eligible for probation, and subsection M mandates that it's consecutive. It's one of the reasons that it would be useful to have a published opinion on this issue so that that could be corrected. There's still a chance that parts of subsection E would be eligible for probation, so an asterisk can be put on the sentencing chart. If it's a second degree offense of luring a minor or the other two offenses listed in subsection E, then those would be probation eligible. And I see I'm out of time. Unless this court has any other questions, we ask that you would affirm the convictions and sentences.
Thank you.
Thank you, Mr. Ball.
Yes, thank you. So as to the purpose of the statute of luring, basically, if there's a solicitation for sex, as we interpreted as one solicitation, that's still a distinct crime from attempt or actually completing a sexual conduct. If the defendant had changed his mind and not shown up, there would still be a solicitation and a crime and a punishment for that, aside from the attempt or even a completed act. So the purpose is satisfied by the solicitation without going to the absurd result of dividing it into 40 different solicitations. That doesn't seem to be in line with what the cases in sort of Majak and Wright v. Gates. Their whole scenario also dealt with a one count of luring for sort of a continuous act toward the goal of sex at the end. And so the grooming is more of evidence of intent. It's not a separate, there's not a statute to punish every separate grooming effort, for example. So that's distinguishable. I guess if there are no further questions, we would ask this court to vacate counts 2 and 3. Thank you.
My question is, and I think we kind of ended on it before, but I'm not sure I understood your answer. If the text messages show evidence that he is having doubts that they have an agreement or that she's going to actually go through with it, why isn't it a new offense when he continues to ask for confirmation that this is going to happen?
I don't believe that's a distinct break in his trying to encourage or solicit sex from her. There's no increased harm by him changing his mind and then coming back to the same.
Now I'm talking about like text 1022, where he is concerned that she has changed her mind.
So I think his concern, he might be concerned, but she indicates that she did not. So it seems to be the same continuing request. If she had changed her mind, then there's an additional harm in trying to get her, back on board. I could see a distinct break there.
So she said, "Ooh, I'm having doubts," but she hasn't affirmatively changed her mind. And he says, "Hey, don't have any doubts." Would that be sufficient?
Possibly. Yeah. Yeah.
It's we're getting into drawing some very fine lines here either way, aren't we?
Well, that the solicitation is a difficult statute. If you look at the other cases, the courts wrestle with, with these things, same issues. But there still has to be sort of a distinct break, and the courts sort of wrestled with that with the rape cases or the sex conduct cases too. Where is the distinct break? But there still has to be evidence of a break for there to be a new unit of prosecution.
Ms. Evans, thank you very much for your time, unless either judge has some other questions. All right. Thank you both for your arguments today. We appreciate it. We will take this matter under advisement and issue a written decision in due course. Thank you.
Thank you.
Thank you, Your Honors.
That we are